From organ transplants to emerging biotechnology, nearly 50 years later, Australia's human tissue laws are back under the microscope. Welcome to Trial by Podcast. I'm Mariana.
And I'm Isabel, and today we're discussing why the Australian Law Reform Commission is currently reviewing the laws that govern organ donation and human tissue use in Australia.
So since the laws were first introduced in 1977, there's been significant social, technological and scientific changes, as you can see, that have made the existing framework in need of updating, essentially. The review is quite broad in scope, covering not just solid organs, but other tissues such as musculoskeletal tissue, bones, heart valves, blood, bone marrow, and even corneas. With the final report due to the Attorney General by August 2026, we're looking at reforms that could harmonise human tissue laws across all Australian jurisdictions. And this would have far-reaching implications for families in difficult times when they have to face really tough decisions about what to do when it comes to things such as organ transplantation, as well as medical practitioners and researchers who rely on these laws to understand their obligations when they're handling human tissue.
It's really going to be quite a profound impact on the way that the medical field and the legal field manage human tissues and organ donations moving forward.
Oh, 100%.
Let's firstly start with a brief overview of the current definitions under the Human Tissue Acts in Australia. Under the Acts, tissue is broadly defined in three categories. We have blood, regenerative tissue, and non-regenerative tissue. Regenerative tissue being tissue which the body replenishes after it is removed, such as bone marrow, compared to a non-regenerative tissue which does not grow back after it is removed, such as a kidney. When examining the tissue donation process, it is essential to understand the point at which a person is officially declared dead in a legal sense. Current definitions articulate that a person has died when there has been irreversible cessation of all brain function or irreversible cessation of blood circulation in the body, which is something I previously wasn't too aware of.
So when it comes to these situations, when we're looking at living donors, people after death, the human tissue laws currently present this really complex web of state and territory regulations governing how we collect, use and dispose of human tissue. And this fragmentation wasn't even initially envisioned.
Yeah.
The ALRC in 1977 had made recommendations for a uniform model law. However, when the states got back to drafting and implementing these laws, they all took different approaches and interpreted things very differently. And they've been making independent amendments ever since. And this current review is particularly significant because it's the first national examination of these laws in nearly 50 years.
Yeah, which is quite imperative to make sure that it's quite uniform within the country. In terms of the review itself, on the 6th of February, the ALRC was asked to inquire into human tissue laws, with the terms of reference being that they're asked to explore matters concerning authorisation to donate, retrieve and transplant human tissue across Australia, inconsistencies across existing laws relating to cell, tissue and organ donation and retrieval arrangements from living and deceased persons, inconsistencies across existing laws definitions of death, post-mortem examinations, whole cadavers and body parts, definitions of tissue, disclosure of information provisions, consent arrangements including for minors, and delegation functions of next of kin, regulation of schools of anatomy and donation for education purposes, frameworks across all Australian jurisdictions relating to donation and retrieval of cells, tissues and organs from living and deceased persons, the advertising of and trade in cells, tissues and organs, and cost recovery, financial and other considerations relating to manufacture and provision of tissue.
So the ALRC has also asked to consider equity and ethical approaches to improving access to cell, tissue and organ transplantation, contemporary and emerging technologies and practices, and international experiences and approaches. So on 26 May 2025, which is quite recent, they published an issues paper as part of its review into these laws. The paper sets out 4 guiding principles designed to ensure that the review produces human tissue laws that are both ethical and just. Because when it comes to biomedicine, there are a lot of medical ethics that come into play when it comes to dealing with these kinds of things, which comes to the core of this review. So the first principle is reform should support increased access to human tissue in Australia. So right now, Australia is facing significant challenges in terms of we just don't have enough tissue available to meet the needs for life-saving treatments. So beyond transplantation, researchers also need to access tissues for studies that could deliver important public health benefits and improve lives more broadly, such as cell lines are often used when developing drugs. These things are critical. Like I think in Queensland they've been developing a vaccine for breast cancer for quite some time. So seeing issues like that come about is actually quite concerning because you want these things to keep progressing and you want Australia's laws to be as uniform as possible so there aren't these roadblocks to such life-transforming developments in science. So in terms of increasing access, it starts with creating a donation system that works effectively and also earns public trust. We can see even in the COVID-19 era that there was a lot of skepticism about the medical profession. So This is especially critical. These systems need to handle everything from retrieving and distributing tissue for transplants to supporting medical research and to training our next generation of doctors. The World Health Organization has set clear standards that transplant procedures must be high quality, safe and effective for both donors and recipients. And any effective systems need strong evidence that the benefit outweighs the risks of undergoing any procedures in relation to this. So when we increase the availability of organs for transplantation, we're not just improving individual health outcomes, but we're saving lives. But we're also working towards the international goal of self-sufficiency, which helps address serious problems like organ trafficking and transplant tourism. The reforms are hoped to promote increased access to human tissue that could focus on 2 key areas. First, making it easier to identify potential donors after death. And second, removing unnecessary barriers that hinder operational efficiency of donation systems.
Yeah, it's very interesting, the scope of where human organ donation and tissue donation lends itself.
Yeah, just beyond even I think the most obvious one would be passing away and donating your organs in that context. But everyone does forget that a lot of the drugs that become available in our chemist warehouses and our price lines are at some point tested on human tissue because they have to by law.
Yeah. And for all the medical advancements we're seeing in this day and age, it is important to have that research element.
Yeah, absolutely critical.
A second principle that they're investigating is respect for persons and the human body as a priority. Respect for persons, which is the foundation of medical ethics, as you just described, encompasses 3 core elements: respecting their human rights, dignity, and autonomy, honouring their beliefs, customs, and cultural heritage, and empowering people to participate in decision-making processes that affect their lives. This principle underpins medical ethics and ethical guidelines for human tissue use. We all understand intuitively that bodies and human remains deserve to be respected and treated with dignity. Critically, this principle creates important limits on efforts to increase tissue donation. As Dr. Megan Toews stated, the human body should never be looked at as a source of spare body parts, remembering that people, even after death, are deserving of dignity. Practical reforms might focus on strengthening autonomy protections for donors, recipients, and others involved, while ensuring consent frameworks genuinely support free, informed choice and self-determination.
So the third principle is that the support of equitable participation in and access to donation and transplantation systems. So the terms of reference of the inquiry encourage consideration of equity and ethical approaches of improving access to transplantation. The concept of equity acknowledges that although individuals are equal, there may be situations where inequalities are inevitable. For instance, equitable distribution of tissue might aim to correct historical disadvantages while also considering the importance of achieving the best possible medical outcome for the donor and or the recipient. Reforms that might promote equity in this situation include amending the Tissue Act, Human Tissue Acts to support equitable participation and access to donation and transplantation systems, and updating the acts to reduce barriers to accessing organ and tissue programs for some groups.
And as we've briefly discussed already, the promotion and upholding of public trust in organ and tissue donation is the fourth principle. In reference to public trust, it involves recognising the importance of maintaining public confidence, and this can be achieved through operating transparently, fairly, and in alignment with their intended purpose. The willingness of people to participate in organ and tissue donation and transplantation systems depends on the degree of trust and confidence in the safe, just, and effective operation of these systems. Systems which provide a clear accountability structure, effective governance, transparent operations, and avenues for public participation in decision-making can promote public trust and confidence. And reforms aimed at promoting and upholding public trust might include amendments to the Human Tissue Acts to ensure legislation is clear and easy to understand, and the implementation of reporting or information sharing requirements to promote transparency in the organisations and the delivery of donation and transplantation activities, while also balancing the privacy of donors and recipients.
So the ALRC identified 6 priority areas for reform. Yeah. The first area being what should be included in the definition of human tissue. So while the current definition is quite expansive, including organs, body parts, and substances, there are questions as to whether it should encompass gametes, such as sperm and egg cells, for situations where there have been a few cases, I think recently, even in WA, I think was the most recent, where the partner or the surviving spouse wants to take or wants to have permission to take the sperm of their deceased partner for various reasons. There's also talks about whether human breast milk should be included in the definition, and also cell lines, particularly important in the context of medical research. The paper also notes that it's not clear whether the definition of tissue should extend to emerging fields such as synthetic biology or bioprinting.
And I think this is a really interesting priority area when you consider the publicisation of the donation of egg cells at the moment, in terms of, as you discussed, for a deceased partner. I remember I've seen a few headlines in news articles about that, cases such as that becoming more and more apparent. So I think that will be an interesting point to look forward to in
like an ethically grey area, and with no guidance.
Exactly.
It presents real issues, and again, like the situation socially is always evolving, and it just shows that something that people probably wouldn't have even thought of at the time these laws were drafted or these recommendations were made have just come so far.
And hopefully this review will be able to give some of that guidance.
Yeah.
Moving on to the second area is the donation of tissues by living persons. Since living donation provides no medical benefit to donors, we need strong safeguards that protect donors from coercion, reinforce respect for their autonomy, and minimise risk to their welfare. Currently, our laws treat regenerative tissue, like bone marrow, differently from non-regenerative tissue, like kidneys, with fewer protections for regenerative tissue donations. This is particularly problematic as the liver is technically regenerative, yet partial liver donation actually carries more risks than some non-regenerative tissue donation. And as such, this is a distinction that may require updating to ensure that the strong safeguards are adequate. A further issue here relates to gaps around research. Some laws only allow non-regenerative tissue for transplantation, not research, which can block legitimate studies. More concerning, tissue removed during surgery can often be used for additional purposes, including research, overseas transfer, or genetic testing without the donor's knowledge or consent. This inquiry proposes to explore how human tissue laws can or should be used to address these gaps. The ALRC also drew attention to inconsistencies regarding the regulation of donated tissue from children, and the fact that the law is largely silent in relation to tissue donation by adults who do not have the legal decision-making capacity. The inquiry aims to promote, as we've discussed, a more uniform approach that can be regulation of donation of tissue from children, namely by consolidating the type of tissue that can be donated, the purpose for which tissue can be donated, different definitions of child and parent, and the role of children and parents in decision-making.
So the third priority area, focuses on donation of tissue after death, which will require consideration of the definition of death and operational issues involving the authorization of tissue donation or removal after the death, and the identification of potential donors and the handling of of donor and recipient information. So currently, as was mentioned earlier, death is defined as the irreversible cessation of either all brain function or blood circulation. So this inquiry will consider updating the definition to include current knowledge about the biological process of death, and to provide guidance as to how new technologies such as normothermic regulation perfusion, which I think relates to the person has died but they can actually stop circulation to the brain, but there is a lot of legally grey area about whether that's even a process that you're allowed to do to obtain organs to keep the blood circulating throughout the body, but keeping the brain technically not with blood flowing in, if that makes sense.
Yes, it's quite a grey area in terms of where that leads us in a legal definition of when someone has passed on.
Yeah, so doctors and medical researchers are facing really tough decisions on whether is it legal to go ahead with some of these processes, because technically having a body work in a certain way according to the definition could mean that the person is still living and you can't take an organ from a living person unless they've consented to it. But if the person's technically dead and they can't say, hey, I'm going to donate my organs now, there's this little grey area that they can't really navigate that the laws really need to catch up to.
Particularly as technologies are increasing. You think of, say, cryogenic freezing and the impacts that will have when the body's technically being stored, in the hope that medical advancements will allow it to be alive again, allow the person to be alive again, rather.
That we might need to take that into another podcast episode. Yeah. That'd be interesting. As for the authorization of tissue donation and removal after death, the inquiry will also consider ways to resolve current inconsistencies and to strengthen the respect for the donor's autonomy and the human body. To lift donor rates, the Commission is also putting the current routine referral process under the spotlight, whereby healthcare staff refer all potential donors to Donate Life. The agency overseeing the donation process. International jurisdictions have legislated mandatory referral, and it is the Commission's agenda to consider whether mandatory referral would prevent missed donation opportunities.
The fourth priority area turns to anatomical and post-mortem examinations, including how consent for body donation is regulated, how schools of anatomy are regulated, and how tissue removed in post-mortem examinations should be used. There is a need for legal clarity about body donation and research, as well as greater consistency about how long bodies can be kept, the transfer of bodies between licensed facilities, data collection, handling of reporting, ethical oversight and governance, and roles and responsibilities of inspectors of anatomy. The Commission also noted that consent requirements for the post-mortem removal of tissue may need strengthening to maintain public trust and appropriately respect individual anatomy.
The fifth priority area relates to advertising and trade in human tissue. So regarding the regulation of trade in human tissue and tissue products, Australia's human tissue laws currently ban paying for human tissue, but there are inconsistencies that exist across states, which actually surprised me to read. While Queensland and Victoria prohibit selling or buying human tissue, other jurisdictions take a broader approach, banning any valuable consideration in exchange for tissue. There are also exceptions to these prohibitions, including ministerial exemptions reimbursement of necessary costs for donors, exemptions for processed or treated tissue, cost recovery for tissue banks and schools of anatomy. And this inevitably creates confusion and operational challenges. The Commission has stated that it may consider how the law in this respect can be clarified and how it could consistently allow ethical exceptions to the prohibition on trade. The Commission has also noted that advertising regulations for the purpose of trade in human tissue are equally inconsistent. So in Victoria, broad prohibitions could theoretically block legitimate community donation campaigns, while other states may have loopholes in allowing potentially unethical commercial markets in human remains. So the Commission is essentially also grappling with these modern challenges like social media solicitation for organ donors and Australia's approach to transplant tourism. While organ trafficking is federally prohibited, Australians can legally travel overseas to purchase organs, a practice that indirectly supports the very trafficking networks Australia opposes.
And finally, the sixth priority area considers the allocation of donated tissue, including whether existing guidelines are sufficient in promoting equitable outcomes and what amendments, if any, could be made to address ongoing concerns about inequities for groups such as First Nations people in accessing organ transplants.
So where does this leave us? The Commission's review represents the most comprehensive examination of Australia's human tissue laws in nearly 50 years.
We're looking at reforms that could fundamentally change how Australia approaches organ donation, medical research and end-of-life care, from clearer consent frameworks to updated definitions of death. These changes could affect every Australian family.
With the final report due next August, the August after this August, we'll be following this quite closely.
Please see the show notes for a link to the issues paper and other interesting articles on this topic. Otherwise, thanks for joining us on Trial by Podcast.
Thank you.